All right, so hello, good evening. Thank you for joining us. My name is Ashley Plies. I'm part of the AIC staff. And of course, here at AIC, we're always trying to find new ways to help people elevate their ideas and get their ideas to the next step. So we are so excited to have sort of partnered with the US Patent and Trademark Office. And we have two wonderful expert patent examiners with us that would like to demystify the patent system. So I'll hand it off to Kathleen Hutchins to get us started.
Hi, everybody. I'm Kathleen. I am a patent examiner with the USPTO. I examine mainly mechanical things. I'm also a mechanical and industrial engineer. Jeff Palaniuk is going to be my partner in crime. He's going to help answer questions. So if you want to go ahead and send questions to him in the Q&A, he will try to address them as we go, so I can just go through the presentation. He's also a patent examiner. He's more chemical side. He examines things in the pharmaceutical side. But let me make sure, can everybody, I need to make sure I'm sharing my screen. That normally helps. Okay, everybody, can somebody let me know that you can see my main screen? It just says Patent Basics and it's a full screen.
Yes, we can see it.
Julie, you raised her hand, thank you. Okay, so we're gonna try to demystify the patent system because there's a lot about patents and a lot of people get very intimidated by it. First off, we're legally required to put this, but the content for this is informational purposes only. It's not legal advice. We're not actually allowed to give legal advice as a federal agency. So please, if you have any specific questions and need advice, please consult appropriate advisors for legal authority and guidance. We also, please notice if I ever present anything that has any type of trademark on it or a company logo, it's just for illustrative purposes and for teaching. It's not us endorsing as USPTO or as the federal government or as myself endorsing any particular product or company. It's just for informational purposes. So here's basically what we're going to go over. First, we're going to do background and then tell you why it's important to think about patents. Then we're going to show you a roadmap about where you might expect the patent to go. And then we're going to show you resources, which is actually probably going to be very useful for you because we have pro bono legal services, we have patent and trademark resource centers, we have a whole slew of resources that are available for inventors or small businesses to take advantage of. Let me just cue up the next slide. So first off, patents is historically a foundation of this country. It is actually part of the Constitution that Congress can permit the government to promote progress, science, and art. So part of this is patents. And that's why we're here as a federal agency. So what specifically is a patent? Because that's actually probably one of the biggest misconceptions. I'm sure you've heard somebody going, or you've used this yourself. I'm guilty before I started at the patent office of saying, oh, I'm going to patent that trademark or trademark that patent, or I'm going to trademark that copyright. It's all incorrect. They're all very different. So a patent specifically is a right to exclude others from making, using, selling, or offering for sale your invention. And notice that this presentation actually says claimed invention. This is an important phrase because the claims, as I will talk to you about later, is a very important part of the legal document that describes your invention. Like, I'll get to that later. I'm not going to get caught up in that right now. But two other points that are very important about patents in the United States is that they are a limited term. We will get to that in a second. And it's territorial, meaning it only applies for the country that you've applied for a patent in. So for example, if you apply for a patent in the US and it's granted to become a patent, it's only enforceable in the US. There's no such thing as a worldwide patent. So those are some very important top features that you need to understand about how a patent works in the United States. So in the US, there's three types of patents. There's utility, design, and a plant patent. A utility is probably the most prevalent thing you've seen. So if you've ever seen anything that has US patent number on it, it probably has US USP and then a whole bunch of numbers after it, usually 6 digits, no, 7 digits. It usually is this type of patent where this is a useful patent. It does something. It's out of article of manufacture, not a design. Next, there's design patents. That's just the look and feel. It's the pretty patents, as it were. So you can see here, the middle one, that's design patent. That's the Statue of Liberty. That's got a design patent on it. It's just the ornamental design of the actual thing. It's not actually how it's made or used. It has no function other than its ornamental design. And then lastly, and probably the least ones you're ever going to encounter, is the plant patents. Those are asexually reproduced plants, or basically human bred. So, hybrids like cuties can be a plant patent, or some of the very specialized poinsettia plants. It's a plant patent. But these aren't the main thing. Most people don't prosecute plant patents. It's very select people get those. So who are we? We're the USPTO. We're called America's Innovation Agency because we foster innovation and economic growth through creating reliable, predictable, and high quality IP systems. IP is intellectual property, which is just the broad bucket that several topics, including patents, trademarks, and copyrights fall into, but we don't administer copyrights. We only administer patents and trademarks, which is why we're USPTO. So you're probably wondering, why should it matter to you to have a patent? Or why should patents matter to you? Well, patents can do a variety of things. One, they can promote innovation and help safeguard your inventions. So you can share your invention without having to worry about someone stealing it, because now if you have a granted patent, you have legal protections to prevent other people from making or using without your permission. It can help companies grow by a variety of means. I've seen companies that their entire business model was basically having patents. You can benefit the community by making new goods and services available. Also, and I'll get to this later, you're providing how to make a device, or how to make an invention, or how to use an invention for the public. And it provides personal growth, development, and advancement. Now, I've seen a lot of companies that have brag walls where they have printed out or bronzed out their granted patent, and they have a wall full of all the patents that have been granted as their brag wall to say, oh, look at all these patents I got. So there's a bunch of reasons why patents might be useful for you, not the least of being you want to protect your actual invention. So even further, and this is from a 2016 study, we have had one that just recently came out, but it came out in between when we made this slide. Patent-intensive industries typically generate a lot of growth and a lot of jobs and a lot of income based off of the intellectual property that they generate. So if you're still interested here, we have just an overview of what a patent looks like. You'll see over here that there's a whole bunch of different things. First and foremost, and it's not pointed out here, is the patent number. Remember how I said you might see a device with a USP and then a bunch of numbers? If I could just, there it is. That's what a US patent is. Second off, there's an issue date, which is important because you want to know how old or how new the patent might be. Titles, your name, meaning the inventor's name, it gets published. The date it was filed, which is important for reasons I will get to in a little bit. Any prior art, meaning anything that's related to it. Have you ever heard the phrase state of the art? That's what we're meaning, the art of that area, what is already out there. Any drawings that might be necessary, and abstract, basically providing a little synopsis of what the invention is. And then there's, of course, claims at the very end, which, remember how I said claimed invention was important? This is the legal definition of your invention, what you consider the metes and bounds of your invention, like what it is, what does it encompass. It's very similar to a deed of property, except it's not going to look similar to a deed of property. It's just going to be one long run-on sentence describing your invention. So here's the sample of a claim. I'm going to mark this up because first off, I'm going to point this out. This is entirely fictitious. We're not at 100 million. And it was granted in January 1, 2040, which is in the future. But this is for illustrative purposes. So we have a chair, which is this whole device here. And I'm sorry, I'm left-handed. I'm using my right hand on the mouse. We have a seat, which is right here. We also have a back support, which is 14 here, which is attached to the seat. Indeed, it is. And then we have support arms, which is there's one here, and there's one here, attached to the seat and back support. Yes, they're connected to both. And a base, which is 10. And plurality, which is just a fancy way of saying more than one of legs, 22. So you can see how this claim is describing the invention. I just have to turn off the pen a second. So a lot of times we ask, especially when we present to the K through 12 STEM, we go, who do you think can be an inventor on a patent? Like what's the age limit? And I get a whole variety of answers. Like I've had somebody go say 21, 16, 45. The true answer is there's no age limit. And anyone who contributes to the conception of the invention can be considered an inventor on the patent. This is either alone in combination with others. So you've probably seen anything in scientific papers where it says, Smith et al. We use the very same conventions of using the et al. To say that there's a combination with other inventors. There is actually one group of people, and we don't mention on here, that cannot be inventors, and it's people that work for the US Patent and Trademark Office cannot be inventors on a patent. If you already have a patent, we're instructed when we swear in and are hired that we have to basically disavow that patent as inventors. But as a university, university students or older, you probably can appreciate the fact that there is a wide variety of people who might contribute to conception or development of the invention. They could all potentially be considered inventors on the patent. So there's a journey to get your patent applied to the USPTO. First, you need an idea. That's pretty typical. You might want to find out if your idea is worth protecting. You have to find out if your idea is actually eligible for protection. So the patent system in the US protects these basic 4 subject matters: a process, a machine, item of manufacture, or composition of matter. Things that are excluded are artwork, for example. They may fall under copyright, a lot of computer programming, and that sort of thing. But if you have a process, a machine, item of manufacture, a composition of matter, you're more than likely eligible for patent protection. Now you notice down here, there is a citation for 35 USC subsection 101. If you actually read it, it's not actually that long. It's just very dense in legalese. It's basically saying this, that you have to have something that's new and useful. It's a process, machine, these 4 things, to be eligible and patentable. So the other prong of test, it's actually 2 prongs, is it this novel or non-obvious? It has to meet both requirements. So if you've already decided that your patent subject matter, say you invented a widget, well, that's an item of manufacture or a machine. Sure, it's eligible. So you have to find out if it's novel and non-obvious. Novel meaning your invention's new and it wasn't described in the prior art. Remember what I said about prior art? It's basically anything that's came before that's been publicly available and describes sufficiently the invention. Non-obvious, on the other hand, is whether or not what your widget does and what the prior art widget does, whether or not those are obvious variants of each other or not. So the example shown is your invention, say, is some type of weed whacker. And then the prior art is a string trimmer. Well, you can see that there's some similarities and differences. And depending on how the claim is structured, you might have an office response or an office action that says that I'm sorry, but it's not not allowable right now because this prior art has very similar ideas. Perhaps the shield doesn't go all the way around, but it's quite obvious to extend the shield a little bit further just because it's a mere change in shape. And I remember how I said in the previous slide about 35 USC subsection 101 and now this is subsections 102 and 103. For those of you that actually want to go look it up, subsection 102 deals with the novel feature, and subsection 103 deals with the non-obvious feature or requirement. So the issue is, how do you know your device or your invention has been made before? It's not disclosed in prior art. Well, first off, prior art can include a whole variety of things. Basically, if you read all of these lists here, this whole list here, it's pretty much anything that could have been published or made publicly available before the effective filing date of your invention. So you can see here, there's like magazines shown. I mean, there's listed patents, printed publications. We call them pre-grant publications, meaning applications that have been filed but haven't yet been approved for a patent. We generally print those before. There's a few exceptions to that. Or any other disclosure. So there's a whole swath of things that might need to be considered as prior art. So if you've already looked through the prior art, say you did a Google search, you're feeling very comfortable that your idea is quite novel and non-obvious, you might want to present your idea as your second step. Now, you also want to make sure you maintain confidentiality, because remember what I said about prior art? Your public disclosure could be considered prior art and can be used against you or used to determine that your invention is not new. In the US, that's generally, you get a 1-year window from public disclosure or offer for sale before you're required to file without it being considered not new or not new. So if you want to present your idea, which as an inventor, you probably do, you don't need to be afraid to champion your idea. Diagrams, drawings are quite helpful, but it's best to maintain the confidentiality prior to filing your patent application to protect your rights to the patent. There are other countries, and I can't comment which countries they are because I'm familiar with US law, but there are other countries that they're first to file, but they also don't give you a 12-month window for public disclosure. So you definitely, in this case, want to consult with counsel about safe ways to disclose your invention. So say you need to present it to a board or you need to present it to investors. You want to find safe ways to disclose your invention before you file a patent application to make sure that you're protecting your rights. So next, after that, you get all excited, you presented, people say, oh, this is a great idea. Well, then you can start drafting your application. I'm not saying you have to have people saying it's a great idea to draft your application, but I'm just trying to tell a story. But after you do these first 2 steps, you can, of course, go to drafting an application. Now, that's what we call it when you apply to get a patent. It's a patent application. We are not a registration state. We are a application state. You have to get approved to become a patent. That's why Jeff and myself are patent examiners, not patent approvers. Our job would be much easier if we could just register, but you do have to provide an application. There are a few things that you do need to disclose. So first off, we, as a patent system, are a quid pro quo. So in exchange for exclusive rights for a select period of time in the United States to your invention, you must fully disclose your invention so that the public can benefit from it and expand on it. And that's why we're here. The federal government would like to have access to your disclosure of your invention, how to make and use it, for example, so that the public can benefit from it. However, they acknowledge that we need to give some type of exchange. So that's why we have the right to exclude for a set period of time. So there's a few questions you need to ask when you provide a disclosure if you're applying for patent. First off, does the disclosure demonstrate the invention? Demonstrate that the inventor was in possession, meaning you knew what you were doing, all of the pieces that you had for the invention were in place. For the claimed invention were in place. Does it teach somebody of ordinary skill in the art and that's varying based on what your art is. If you're in nuclear physics, probably a nuclear physicist, but if you're working on screws, maybe it's a simple, anybody that can use simple mechanical tools. Does it teach somebody of ordinary skill in the art how to make and use the invention without undue experimentation? So you can't just leave out the most important part of your invention. Does it describe the best mode that you consider to carry out the invention or by the inventor? You can't, we don't want to just see, oh, you can do this, without understanding what the best mode is. So remember the claims I keep referring to? This is where we're getting to really the meaty part. So you want to know if the claims are clear enough that the public is informed on the boundaries of an invention. They know what your invention is, what it would not be. It's basically so that the public knows whether or not they're infringing upon your invention. And can it be determined whether the claimed invention meets all the criteria of patentability? So remember those 3 requirements I had, the section 101, which is whether or not it is eligible subject matter, section 102, which is whether or not it is novel, and section 103, and whether or not it is non-obvious. So then lastly, once you have an application drafted, you can go ahead and file the application. It's filed with the USPTO. You need to file a sworn oath or declaration that you invented as the invention as described in the application. And of course, there are some fees involved because we're a fee-funded agency. We do charge fees, much like the post office charges stamp fees to do the delivery. We charge fees to do examination. We are not taxpayer funded, so our salaries are funded by the fees that are submitted to us for examination. You might want to note that the Patent Office does give discounts for these 2 entities called microentity on the right-hand side and small entity. There's a few details about what is a microentity versus a small entity versus a large entity, and you can actually look this up online. If you go to our USPTO.gov website, just type in the search column, just type microentity, and it should pop up really fairly close, if not to the top, about what the requirements are. But basically, the income threshold for microentity at this moment is about $206,000 per year. It's based off of how many times the minimum it is. This, however, does not provide for basic attorney fees. I'm sorry, somebody jailbroke into my office. I forgot to lock the door. But this is just the basic fees that you need to pay for application. You, of course, do not need to retain an attorney. You can do something called pro se applicants, which is for yourself. I will get to help that we have available for pro se applicants in a little bit. So the patent application roadmap is basically, it's not a straight, this is very deceiving. It's not a straight going application filed straight to patent. There's some things that will go on. So a patent typically will get to an examiner, and an examiner will look at it, search the prior art, see if your ideas or your claimed invention has been done before, and may provide rejections or objections. There's a bit of administrative difference between a rejection and objection, but ultimately we have to understand is that the examiner is trying to get valid quality patents issued. So once it goes to the examiner, if they provide you an office action that's a rejection, you have an opportunity to do an amendment, meaning you can change the claims or change the drawings and the spec as required by an objection from the examiner, or you can argue against the rejection, saying, no, this is not at all what your reference says, or this is not what my claims say. You're wrong, it should become a patent. Or you can do a combination of the both. So oftentimes there's a lot of back and forth going on between everybody, basically. And in my experience, a first action allowance, meaning you don't get any type of rejection, you just get, oh yeah, sure, this is great, get a patent, is very rare. I only do a handful a year. And I get quite a few patent applications through my desk in a year. But here's my role and Jeff's role at the USPTO as examiner. We need to read and understand the application. We all specialize in specific areas. Remember I said I worked in mechanical petroleum engineering area and Jeff works in pharmaceuticals. We specialize so we understand the technology and the art better. We have to search for prior art. We do have to evaluate the specification and the claims for completeness and for adherence to all the legal things. We also need to respond with office actions or an office action to describe our findings. It may be that it's able to be granted to become a patent immediately, maybe not. We also are responsible for holding interviews as requested by applicant. So an applicant's role is to file a complete application. Also to disclose all known prior art that's applicable for that particular invention and respond to examiner office actions. You will want to explain your position or make good faith changes to the application or a combination of both. So I keep saying office action, like you guys know what I'm talking about. You've been at the PTO for a long time. This is any communication that has a basis for objections, rejections, or allowability. Basically, it looks like this. There's a cover sheet, there's a little checkbox sheet, and then there's actual written description behind it. I usually do quite in-depth ones. I try to make sure that there's no question on where I'm coming from. So remember how I said that an examiner might reject your application? What does a rejection actually mean? Don't panic. It's a normal part of the process. This actually typically happens a lot. It's trying to help define what's patentable. It's often used because of existing prior art, because some part, your claimed invention as it's claimed, remember I keep saying the word claimed, as is written in its description for the claim, has already been done. So we have to have a basis and we have to have proof to believe why someone else might have come up with your invention. We can't just say we feel like it's already there. We have to have provide proof, and that's in reference to prior art. We usually supply the prior art, or it's a US patent or a pre-grant publication that should be easily able to be looked up. This can also often be overcome. Remember I talked about having either arguments about why it's incorrect or why the reference does not read on it, or amendments to get around the prior art to further define your invention. So if you get a rejection, don't give up. This fiscal year, this is a little old, so we have to update this, but fiscal year 2019, first actions were 16% of all first actions were actually allowances. 84% were rejections. But overall, more than half of all office actions or disposals were actually allowances. We call it disposal when you get to a final office action, not a final office, when either the applicant gives up and goes, oh, okay, fine, I abandon the case, or it becomes allowed, meaning it's allowed to become a patent and they get a patent. So remember I talked about one of the roles of examiner is to have an interview? Well, here describes what the power of the interview is. You can see that the allowance rate for cases that have had interviews is 80%. But without interviews, it's only 67%. So by far, having an interview vastly increases the probability or chances of you being able to get a patent. Now, it's not guaranteeing that if you have an interview, you'll get a patent out of it, but this is to demonstrate the power or the importance of having an interview with your patent examiner. So here's some after final practice tips. This is meaning, remember I said you can get a final, meaning they go, no, you can't get a patent, here's why. From your office action, you go, okay, well, what if I make this change or I argue, and then they go, no, and that's final. Even if you receive a final rejection, don't panic. It's not the end of the world. If you still disagree, you have a couple of options. You can file something called an RC, which is a request for continuing examination. You can file an appeal or an after final response. it's not over just because this is final, even though it sounds like it's final. It's not over. You can, if you're strongly convicted that you're correct or that you have something that is patentable, you can work with the examiner or do these other options. So you're probably wondering how long is this going to take, and I am sorry to tell you this, but it's actually a pretty long process. We get thousands of patent applications a year. And we are working as fast as we can and still as accurately as we can. It does take some time to examine a single application. But typically, based on, this is from 2 years ago, on this data, you basically are going to wait about 14. It's a little bit higher now because we've had a lot more applications come in, 14 months before you can get your first action. And then you have all of these other things going on. So, you know, if your case is allowable to be a patent, a little over 25 months to get a patent granted. And this is on average. So it might go faster, it might go slower. It just depends on a lot of factors. So if you get to the point where it becomes, it's allowed to be a patent, now you're getting to allowance and issuance. So a notice of allowance will indicate that it can become a patent. You have to pay an issue fee, but you now, once you pay the issue fee, you can have a patent. And congratulations. You also get this little fancy, actually, I don't think they issue this anymore. They used to issue a physical patent where it had this fancy document. And that's what it looks like. And it's signed by the current director of the USPTO. This is what people put up on their brag wall. So remember, you can stay involved throughout the whole process. You don't have to think that if you got a rejection or a final that you're out of the game. If you still want to prosecute or pursue it, you can keep staying involved. Now, probably the most important part of this whole series is going to be this: what assistance and resources we have available for small businesses, innovators, and inventors. Well, you can first off start off with our different regional offices. So myself, I am working for the Western Regional Office, which is right here in San Jose, California. Just because we're in Silicon Valley doesn't mean we don't service everybody else in all of these states in orange. There's several other ones, and there's also a headquarters, which is in DC, or actually Alexandria, Virginia. You can contact any of us or go to the USPTO.gov website, which is right here in the lower right-hand side. You can also see that there's a whole list over here. I will cover a few select important ones in a second. We also have a website that has all of our free services broken down on whether or not you need patents, trademarks, or to find attorney or business advisors. This is kind of a long link, I apologize. But it's basically, if you can find the USPTO.gov website, there is on the right-hand side currently. They change it a little bit sometimes, but currently on the right-hand side, they have free services. That's the link you want to click on. We also have an Inventor Assistance Center. These are staffed by retired or former supervisory patent examiners, basically somebody that would be like my boss, and experienced primary examiners like Jeff or myself that answer general questions about patent examining policy and procedure. And you can reach them. They have a pretty wide band of operation considering they're in Eastern time, but you can go ahead and call them and ask any general questions you have. And this is completely free and it's available to the public. We also have a USPTO pro bono program. So the phrase pro bono means for the good. It's a free program or a very low cost program that assists financially underserved inventors and small businesses. So that you do have to have income below 300% or 300% below the federal poverty guidelines, which you're going to have to check up to make sure. But this is an excellent source for attorneys that are donating their time to provide advice and help with prosecuting, meaning trying to get a patent. So if you are interested in that, you can go to the USPTO.gov/pro bono patents website. Please note that the Alaska, I believe, is covered with the California Lawyers for the Art, which is the CLA not intuitive because it's not arts technically. That's the pro bono program that covers Alaska. They're based out of California. You do not need to actually have an attorney in Alaska. You can have an attorney from, as long as they are a patent attorney registered with the United States Patent and Trademark Office, then you can work with them. There's also something called law school clinics. We have a variety of law schools across the country that are participating in this program. They provide low or no cost legal advice and help for applying for a patent through their law school. They're supervised by a qualified patent attorney or a law professor. Now, some of these have requirements where you need to be in the state that they are servicing, some do not. So you're going to have to check which ones have the requirements that will meet your needs. So you can go to this website, which is the uspto.gov/law school clinic. I should mention that these two programs, that while they provide free or low cost, very low cost or nominal cost legal advice and help, they cannot subsidize or pay for your applications. So at that point, you are going to have to evaluate if you need to apply for microentity status, for example, for the reduced fee schedule. And then we also have the PTRCs, the Patent Trademark Resource Centers. So you'll notice there's one in Alaska. And Fairbanks. These places are a nationwide network of public, state, and academic libraries that provide access to USPTO information and search tools. So they are especially trained to assist inventors. So you might want to check them out. And then last, we have, this is just the general listing, and you should be able to get the presentation with the links for all of the different assistance sections that we have. And we also have a helpline. You can try calling them as well. But you might want to start off with the more specific things that would actually help you. So thank you. If you want to see the EndNote for that study from the 2016, we do have an updated version. It just didn't make it into this set of slides. But thank you. If you have any questions, any further questions that we can't get to today, you can, of course, email us at siliconvalley@uspto.gov, and we will be happy to answer your questions as best we can. So let me see if I can stop sharing, and we'll see if there are any questions, if Jeff has not efficiently gotten to them already.
Actually, one just populated into the chat. Can I patent something? Okay, sorry. Can I patent something that I invented that is assembled with wood screws from Home Depot? So if I'm understanding the question correctly, if you've created something and used a product that is something that you acquired from a box retailer like Home Depot, it's possible. I mean, the screws are, as we can all
people use
surmise,
screws all the time, and they don't invent their own
so
screws.
Those are of themselves not inventive, but it depends on what it is that you've created beyond that. So one of the pillars of acquiring a patent or new IP is, how is it, like Kathleen said, is it new, is it innovative, is it non-obvious, but is it also an improvement on something that's already been done before? So again, one of our go-to phrases is it depends.
Okay.
Douglas,
so short
is
answer,
asking,
you can definitely make inventions using sourced parts. I mean, that's absolutely ridiculous to expect everyone to be like, I invented a new screw too for everything, because that's just not practical. I mean, to be honest, Tesla has a design patent for the shape of Tesla, and they have a design for like the cooling unit for its battery system, but I'm pretty sure they didn't invent a whole new hose to conduct the cooling fluid. You know what I mean?
Right. Yes.
So Mark, I hope that answered your question.
Sorry.
All right. So should we move over to Douglas's
next question from Douglas is, can you go over the quote non-obvious requirement? The verbiage on the slide was confusing to me.
Okay. Let me open up the Let me just queue it up and then I'll see if I can explain it a little bit more. They put 2 statutory requirements in one slide. These slides, because we're federal government, we have to have approved slides. So we use a set of approved slides, basically. So when I say they, it's because I did make the slides. Okay, can everybody see my, oh, there we go, for sharing. So this non-obvious means what you're claiming, whatever the improvement is, would it have been obvious to somebody of ordinary skill in the art in that field? So I did talk about how somebody having ordinary skill in the art in the field can vary depending on what your invention is. If it's a nuclear device, one of ordinary skill in the art is probably a nuclear physicist. But if it's, say, a weed whacker, it's probably just somebody that understands how to use a weed whacker, which could be just an average person. The non-obvious part is, and this is just an example, say the claim said that you have a grass trimmer with a cutting device that spins, and then you have a shroud that extends from 0 degrees, 90 degrees around, or right, yeah, let's go with that. And you have prior art where this is showing a trimmer with a very narrow range for the guard. Well, the claim says the guard has to go, sorry, not 90 degrees, 180 degrees. Let's just call that 180 degrees, around. So halfway around the circumference. As an examiner, I would say, yeah, I have the trimmer, I've got the weed whacker, I've got a guard. It's just not that whole swath. So it would be obvious to somebody to just make it a little bit bigger. It's just an obvious change of shape or a change of size. That's what I was talking about, non-obvious, meaning it can't just be like Jeff uses this phrase a lot. Well, duh,
Sorry,
it has to be something.
So the difference
I'm
that I like the difference that I try to equate novelty versus non-obviousness, and I'm wondering, Doug, if your question about the verbiage on the slide is because it's seemingly the non-obvious passage kind of uses seemingly a double negative. So when we say something is either novel or non-obvious, novel means it's either there or it's not. It's like, take for example, like a multiple choice question. There's a definitive answer. With non-obvious, I like to equate that as being the essay answer. So we look back, as Kathleen was saying, we look back in the totality of what has been done leading up to your invention. And if we can piece something together to show that there is something that could have been concluded that, well, if you just, like Kathleen says, if you just tweak the diameter of the protective covering for the weed whacker, well, why wouldn't you have done that? As she said that I said, why isn't that just like a duh invention? If you've often caught yourself saying, I could have invented that, that's kind of, it's grossly, it's maybe understating the entirety of the concept, but it kind of oversimplifying it, but it leads, that's kind of the premise of obviousness. Based on everything that has been done leading up to this, would somebody conceivably have thought to have made that change? Possibly. So it's in our estimation, from both our standpoints, it's a harder bar to get over in terms of patentability. So sorry to run.
That's where the art of examining comes into place, because it's
yes, exactly.
What's obvious to one person might not be obvious to another person. That's the difficult part of the job.
Yes.
Of our job is this an obvious combination? Would it be obvious to put this feature onto another feature? Okay, so Mark is asking, I'm sorry if you all can hear that. I got 2 naughty little kids home and one not very tolerant husband. So Mark is asking,
yeah.
can I patent a new and novel and improved assembly process for something that already exists? So the short answer is it depends. There certainly are patents that are granted for improvements. It just depends on how much improvement you're providing over something that already exists, right? Is the improvement obvious? Then you're probably not going to be able to get it granted. But if it's non-obvious, then possibly, yes. Don't apply and then get a rejection and be like, well, examiner Hutchins said it was allowable. But there are definitely people that do get patents for improvements. I mean, think of the light bulb, right? Thomas Edison made a light bulb. I have a really good but not yet approved slide that shows a progression of light bulbs. Now we have LEDs. It's all based off of Thomas Edison's idea of creating a light bulb that has the little filament that heats up and creates light in a vacuum. Does that mean no one ever invented any other type of light emitting device? No. People have improved and made new things based off of that idea. That's the exact reason why we have patents. Nobody would have figured out that Edison had a vacuum in that, because you wouldn't be able to ever detect that. You would pop it open and boom, air. Nobody could get it to work as well without a vacuum, right? But now we have LEDs. We have, what are those chemical ones that buzz? They're really ugly. Yeah, those. But those are all improvements on the original idea of having fluorescent lights. Those are all improvements. So you entirely could possibly get an improvement off of an already existing idea. So I hope that answers your question, Mark.
The key element in your question is improved assembly. What is that improvement? If you know, if you're coming to the table with something that you feel is known or in your estimation novel, what is that improvement over what has been done? And what are the benefits or the unexpected results or advantages? Those are key buzzwords that we as examiners look for.
That is.
What is the unexpected result? What is the unexpected contribution to the art that your invention is improving upon?
Or it could just be
that is what you want to focus in on. Yeah.
Yeah, if Jeff was on camera, you'd be seeing his dog, and we've gotten compliments about his dog more than compliments about our presentations.
She's passed out. She's not doing anything.
She's very fluffy. Okay, does anyone else have any more questions or want me to reiterate a particular slide if it was confusing? Because I wanted to make sure I had enough time for questions, so I kept it short and sweet.
Slides are going to be available for the presentation. We can absolutely make the slideshow presentation available. We'll PDF it and send it on.
And send it on, right, we'll send it to Ashley. So Douglas is asking about a design patent versus a copyright. So let me actually queue up. There are some subtle differences between a design patent and a copyright. This is actually very ripe for the STEM, the STEM program I have. So Douglas is saying that for a copyright, you can copyright a work of art, for example. So he's entirely right. But I think the distinction is that for a design patent, it's actually something that could also have utility and not just aesthetics. I know I said it's mostly aesthetics, but you could have a design patent for a chair, for example, something you could manufacture or use. The example of the Statue of Liberty probably wasn't the best, because you probably could have got a copyright of the Statue of Liberty instead of a design patent. There's also differences in statutory coverage between a design patent and a copyright, as well as enforcement. So typically a copyright is 50 years after the death of the maker. I have to pull up I'm not a copyright expert, so I have to pull up the slides.
I think it's 70 years. And Or the
it's
alternative
something
is 95 years from the date
redonkulously,
of creation.
right? It's something redonkulously
Designed to
long.
be designed to grant protection for the lifetime of the creator.
Right. But and this is going to sound bad, but design patents are 15 years from date of grant.
Correct, Douglas. You would get a copyright for a work of art. Copyrights cover copyrights cover a lot of things that you see every day: books, music, lyrics,
architectural works. I'm pulling up the presentation that describes it. Right. If I could
Dance
just
routines. I'm sure you guys watch sports events all the time. If you ever hear that little disclaimer from like Major League Baseball saying that you don't have the right,
any type of,
you cannot reproduce
broadcast
anything here without the express written consent of Major League Baseball.
Yeah.
That is a disclaimer saying,
Julie, is it okay if
for copyrights.
If I share the Anchorage Stream Academy presentation here, because that has the copyright section?
So certainly.
Okay. So this is actually the official slide that says it's originally works of authorship. So a design patent is not, I guess, considered original works of authorship, to get into the weeds of things. So copyright can include music, artistic type of things. I think we have a good illustration. And it has to be fixed in a tangible form of expression, meaning it has to have been published or released, like a YouTube video, for example. There's no such requirement for design patents. It's just you just submit the design in the application and that's it. There's a whole list here. It's very boring because it's just a lot of words, but it covers a lot more than what a design patent would, and it has a very different, there we go. You're right, Jeff, plus 70 years or 95 years from publication. Not the same as a design patent. So there's also exclusive rights for copyright owners, and it's different for a design patent owner. So you can perform or display or authorize others to do so and reproduce the work. Whereas design basically excludes them from anybody else from making, using, selling, or offering for sale or importing your claimed invention. And there's the same, we use the same graphics a lot. Just to let you a little peek into what we're doing. Okay. So that was the difference between design patents and copyrights. So. Does anybody else have any other questions?
Actually, that's a really good question. I don't think we've actually ever had that question before, Kathleen. Like, if you have a work of art, why can't you get a design patent versus a copyright? To be perfectly honest, I don't see why you can't apply for both. If it's a work of art, get the copyright. If it's something of ornamental design, go ahead and apply for the design patent as well.
They both offer different degrees of protection and different lengths of protection.
Exactly.
I believe
and whatever is within your budget to do business-wise, that's for your own self-evaluation.
Okay, so Douglas is getting his Google on. Interesting emojis that can't design patents. Oh, so if we have a little bit of time, I think. Y'all want to play a very short game? Okay, I'm going to share the screen. You guys can type this in if you're still listening. So this is a game I play with kids. Remember how I showed you something that had a really fancy name title? So we're going to try to take, these are actual patent titles, and see what the invention actually is. So what do you think an occupant-propelled wheeled land vehicle is? Bicycle, job. What about a small mammal trap device? The kid at the Stream Academy in Anchorage guessed a bear trap. I'm like, small mammal? They told me it's Alaska. Moose are bigger. So a small mammal trap device is actually a mousetrap. Sometimes they have some interestingly fancy titles that are technical titles, but they're actually something pretty simple, like this horological instrument with musical simulated avian. Hint, horological means clock. If you have questions, you can type it in now. We just have a few more minutes, so I thought I'd fill it. I like this game. It's really fun. Jeff, what's the answer for this?
Oh, the third one?
Horological instrument with musical simulated avian. Cuckoo clock.
Exactly.
Yes, good
Mark
job,
got
Mark.
it. Mark beat me to it.
Yeah. And then the generally spherical object with floppy filaments to promote sure capture. This is the actual title for this invention. If Julie's camera on, I'm sure she'd be holding it up, but that's the hint, upper right hand corner. It's a koosh ball. That's actually the title of the patent, because I think I have the patent right before. It's just, this is a fun game I play with the kids when I do STEM activities to guess the actual title, what it actually is claiming. So you can see how technical things aren't necessarily exactly what lay people would say, which is why people get very confused about patents. They go, oh, it's so complicated. Doesn't help that the koosh ball has got a very long name for a koosh ball. Okay, well, if this is the last call for questions, since it's getting close to the end time. You're welcome for the presentation. I enjoyed giving it.
Also, we want to emphasize too that if you guys have any questions beyond the scope of this or beyond the time of this presentation, don't hesitate to reach out to us at Silicon Valley. Our email is siliconvalley@uspto.gov.
That loud clacking is me typing. I'm typing it in right now.
You put it in there right now?
Feel free to email that.
And I just wanted to add an additional reminder. We have our quarterly Path to a Patent series. It's an 8-part series that starts this Thursday, tomorrow. It's at 11 a.m. Pacific time, so I'm guessing 10 a.m. Alaska time. We'd love to have you join that educational series.
And Jeff and I will be giving next week's lecture. So if you want to see more of us, that's where we'll be.
The event is free and available on our website to register for through Eventbrite. See if we can get you the link here.
I'm
real
pulling
quick.
it up. You can go to our.
You got it? Okay.
Thank you, Jeff. It'll be right here. So you can see once Jeff sends you the link, the list is here. It's the, wow, we have a lot of events going on.
Yeah, we do. I'm getting there.
It is here somewhere.
Just at
is it not listed here?
It's at the very top. It should be right there. See where it says webinar? Just click on the webinar.
Oh, there you go.
I'm not quite sure why it's not showing up.
I haven't checked this in a hot minute. So.
I got it.
Oh, I think my system's not liking it.
Here, I posted the link to the page, Path to a Patent Part 1, IP Basics, excuse me. You'll see a register today after all the regional office links. If you click on that, it'll take you to a third-party Eventbrite link where you can register for the event for free. And you'll probably, if you do attend that, you will hear a number of concepts and topics that we talked about here, or that, excuse me, Kathleen talked about here tonight. And if there's any questions that you want, we'll have at least, I think, 2 or 3 probably other primary examiners on that, myself included, to field what questions you have. So if you think of something after tonight, attend the event, ask it there. If not, email us directly and we'll get back to you as soon as we can.
We get into a lot more depth detail for the topics because we have a lot more time per topic. We're not just trying to cover everything all at once. So it's an hour and a half. Typically it's an hour of presentation and then half an hour of Q&A. But of course you can do Q&A while we're giving the talk, much like we did today.
First question.
So thank
roller
you.
Skis? Go for it. Email us that question. If you've got a question about roller skis, Mark, go for it.
Sounds
Email
dangerous and exciting.
I'm curious.
But Ashley, thank you for having us. We really
Yeah, well, thank
appreciate
you for
it.
joining.
Thank you again.
I hope everyone had a great time. It was very informational, and we'll see y'all later.
Thank you.
Good night.
Bye-bye.
Bye.